Good afternoon, everyone, and welcome to the Canberra Business Chamber's webinar on closing loophole changes impacting your business. I'm Greg Harford, if you don't know me, the Chief Executive of the Canberra Business Chamber, and I'm really excited to have Olivia Perry here with us today. Olivia is one of our senior workplace relations consultants who helps members and others on topics such as performance management, redundancies, and employment contracts. So all the good stuff that is really, really important to get right. So, as you know, the government put in place some changes to the Fair Work Act last year called the Closing Loophole Bill, the Fair Work Closing Loopholes Act. Olivia is going to run through those changes with us. We're going to talk about changes to casual employment, wage compliance and contractors. We'll talk about hiring, workforce management, employer obligations, and some practical steps. It is important to get this right and avoid penalties and make sure that we don't all end up in front of the Fair Work Commission. So with that, I'll hand over to Olivia. But before I do, I'll just note that we do have time for questions at the end of this webinar. So please just use the Q&A function at the bottom of your webinar screen, and we'll get to those at the end. But in the meantime, I'll hand over to Olivia. Welcome.
Thank you very much. Just moving quickly through to our disclaimer, but just want to quickly note before we start, if my connection or we have any technical difficulties come up and you're unable to hear me or see the PowerPoint, just let me know at any point. We obviously hope that it goes seamlessly, but not always the case. So please let me know if that's having any issues at all. Moving through to obviously a few of our closing loophole changes. I did just want to obviously note that we're not going to be going through every single one of these today, but I'm going to really be looking at some of the ones that have been towards the end of 2024 as well as coming into 2025. So really focusing on those ones, as well as obviously the large ones that are really affecting the businesses. Obviously, this is quite a large influx of changes. It has been unusual, I suppose, to have such a large amount of changes within a 3-year span, but that is kind of why they're based over a 3-year span. So it's not a large risk or compliance process for businesses as they're working through all of these different changes. Basically, they were introduced through the Closing Loopholes Bill of 2023 through the Labor government to sort of basically, as you can imagine by the title, close those loopholes or gaps in employment law that have historically kind of been more unfair practices. The bill was from about the 7th of December 2022, and as I said, kind of divided into 2 trenches so that there isn't too much that employers have to take on at once. With that sort of Fair Work legislation amendment, went through assent, royal assent apologies, and all those changes will be taking effect from basically December 2023 up until around February 2025. Just noting with small businesses, there is that continuation up until about the 26th of August 2025, which we'll touch on that right to disconnect element a little bit later along. Some really key changes, as mentioned, right to disconnect, quite a large one, especially one that employees are very aware of with these changes. There's a few others in terms of the changes to underpayments, which we'll touch on, the new definitions of employee and employer, the new definition and process for a casual worker, which again has been one that is quite prominent within businesses and one we'll touch on quite highly. A few that we probably won't touch on too much, things such as the regulations for your road transport workers, dispute resolution mechanisms for unfair contracts, and a few of the enterprise arrangement or enterprise bargaining provisions and changes that were more towards the end, the start, apologies, of 2024. But I did just want to note, if you are worried in regards to any of those changes, or if you want to confirm whether those changes are going to be relevant to you as a business, please just feel free to call the line. All of our consultants are very aware of all these changes. And again, most people aren't under an enterprise bargaining arrangement, but if you are, that may be where you'd like to have a conversation with one of our consultants a little bit more, just to make sure that you're looking at all those processes essentially. As you can kind of see, most of these changes likely should have already been within your business at this stage. But realistically, I really want to focus on that new wage criminalisation, and obviously that right to disconnect change that is really coming prominent within 2025. But we are going to start here with the types of employment, and obviously casual employment, so that redefinition of casual employment. So with that redefinition of the casual employment, basically the main case or the focus that we were looking at was the High Court case of WorkPac versus Rosado. To give you a little bit of breakdown of that, in summary, basically it involved Mr. Rosado, who worked as a casual employee for a mining company over a period of 3 years. So despite being labelled as a casual, the Rosado worked really regular and predictable shifts by the definition of that regular and systematic. So the central question that was basically brought forward was whether the employee needed to be classified as a casual, but working regular hours, or as a permanent employee, and whether as a permanent employee, obviously then he would be eligible for paid entitlements and benefits, much like your annual leave loading. In addition to that, of course, as well, I did just want to note it, with that change of whether they're casual or whether they're a permanent employee, that does actually change the access to unfair dismissal. So that does add an extra layer of why it's very important that when we're looking at casuals, we're making sure that the definition of casuals is being met, and that regular and systematic definition is really being looked at when looking at a roster process. Basically, with that ruling, this was delivered in 2020. It ruled in favour of Rosado, and basically determined that despite being classified as a casual by the business, the consistent work pattern indicated more of a permanent employment relationship. As a result, obviously, the court was then found that Mr. Rosado was entitled to paid leave entitlements under the National Employment Standards. And that case has really prompted this significant leave and legislation changes within Australia. Previously, I will say the definition of casual employees and the rights of those were quite limited in terms of how the definition states that. And basically this changes, and the changes from this Rosado case, was to truly make sure that employers as well as employees are aware of what a casual employment should look like, and that redefinition of the process from there. So some of the key changes from the Fair Work closing loophole changes were basically that introduction or a statutory definition of a casual employee. And again, that was just to provide clarity. So a casual employee is now kind of defined more as someone who accepts a job offer from an employer, knowing that there's no firm advance commitment to ongoing work with an agreed pattern of work. So again, I kind of might say that again, but really looking at those words of firm advance commitment to ongoing work and an agreed pattern of work. And something I always like to focus on with that is, do you maybe have other employees who are in the same role who are permanent that could have a factor on that casual basis? And without sounding terrible, I always try to focus on the saying of, if it walks like a duck and quacks like a duck, it's most likely a duck. So, when looking at the roster and the ongoing element of work for an employee, if you're feeling as though from a third party reasonable perspective that they're looking more like a part-timer or a full-timer, then it's likely that they are that part-timer or full-timer. So with those changes, just to let everyone know, that is under Section 15A of the Fair Work Act now. There's a few elements. Obviously, I have noted that there's that no firm advancement or commitment to indefinite work. But with that, the employee as a casual is, as per normal, entitled to a casual loaded rate if they are casual, or entitled to permanent National Employment Standards leave requirements if they are transitioned to permanent. And as you'd imagine, determining that existence of a firm advance commitment requires a lot of consideration of this real substantial practicality of the relationship between the employee and the employer. So a few things to consider with that is, can the employer choose to offer the employee work? Or can the employee choose to accept or reject this offer, basically? And has that employee got a regular pattern of work? It's difficult, I guess, to say what a regular pattern of work may look like. And you really, again, kind of need to look at it from that reasonable person perspective or that third party perspective. Basically, previously there were a few changes in regard to that offer of casual employment. So now, after 6 months of work or 12 months in a small business, employees can choose to notify their employer in writing if they believe that they no longer meet that definition or standard. And employers then have 21 days to respond to this request. And I'll go through a little bit more of that process in a couple of slides as well. So just sort of to really focus on that definition a little bit more, obviously you will get a copy of this PowerPoint and recording also, but again, that firm advance commitment to continue indefinite work. And obviously, as you can imagine, as I've mentioned, to be paid casual loading in that. So in determining the firm advance commitment, consideration, and this is, again, as per the Fair Work Act, that real substance, practical reality, and true nature of the employment relationship. That might be found within the terms of an employment contract or in the form of mutual understanding as well. So that can have a factor in the scenario also. So with those claims for permanent employment as well, so basically because the employee can request that, at any stage throughout the period as well, even if they're under 6 months and they're requesting maybe change or to be looking at the roster, I wouldn't not take that into consideration if they're under the 6-month period, because realistically and practically they're going to get to that 6-month period soon enough anyway. So even if they're out a 3-month, 4-month period, just really taking into that consideration and communication basis that you may need to look at whether there's that firm advance commitment or continuation of indefinite work. There we go. Just another few dot points. I've gone through this already, but whether there are full-time employees or part-time employees performing the same kind of work, a really good indicator of whether there's that firm advance commitment to a continuation of work. Whether there's that regular pattern, again, I've kind of noted it in the brackets here, but that can't be, of course, absolutely uniform. It may fluctuate due to illness, injury, uni, whatever it may be. So not always an indicator of whether an employee or a casual is a true casual. So I wouldn't take that into the only consideration of that change for casual employment, but we'd definitely be looking at your rosters to ensure that, if you're looking at a certain employee, if they're doing every single Tuesday to Thursday 9 to 5, that there is sort of that regular pattern, essentially. Another factor to that, which sometimes isn't taken into consideration, is that indefinite work element. So if you've got someone who works, I'll use a bit of a employee example, but maybe as a support worker, and they've got a client who they specifically work with, and that is why they've got that continuation of the same day, because that's when the support worker or the client is required to work that day. That may not mean that there's that firm advancement commitment or indefinite work, because that is so contingent on whether the client is required to have the support worker on that day, or whether that client wishes to continue for an ongoing period of time. So keeping that in mind as well, with that indefinite work element, that can be a reason potentially as to why you keep a staff member as a casual. this is a similar sort of process. Obviously, we'll need to meet as casuals that definition. So you can see that in the blue section here. This is sort of a reiteration of what we've already discussed in relation, to that firm advance commitment for indefinite work. So have they become a permanent employees? Sometimes they can't be a simple morph into permanent employees. Obviously, if they're incorrectly engaged as a casual at the start of employment, they may remain a casual, or they may just decide to make that choice. Even if you do feel as though a permanent employee is that more accurate definition of them, the employee may choose based on uni, based on higher salary, whatever it may be, to remain a casual employee. And I would suggest, if that's the case, to make sure that you've got really stringent reporting categories for that. So whether it be a document that is signed or a record of discussion that is signed to note that that is the employee's choice to remain casual. It just means that as a business, you're protecting yourself to note that that was the employee's choice. You understand and consider the fact that they may have more eligibility as a permanent employee. However, based on that employee choice process, you have that requirement or that understanding that the employee will remain casual. So that is just in this employee choice process here. As mentioned, just sort of going through a few of that 21 days to respond option. Basically, if an employee issues a new notification that they would like to change full-time or part-time, again, sort of a tick box here that you can maybe follow in terms of that process. So basically that they believe that they no longer meet the requirements of a casual employment definition, and have been employed for that period of 6 months or 12 months for a small business employer. Just to quickly note, sorry, I haven't noticed this before, but as a small business employer, that definition is 15 employees or less. So keeping that in the back of your mind whenever I'm noting a small business. Again, employers have that 21 days to respond, whether that be an acceptance or a decline or rejection of that casual conversion. So they may not meet that definition that you feel as though as an employer. So that may be a decline or rejection from that end. Obviously, if it's accepted, you'll then go through that process of potentially a new employment contract, redirecting them to a more permanent process. And in that, obviously, you will be having to give a roster and an understanding of their hours and having that communication and discussion with the employee as well. So reasons that you may be able to decline, again, I've kind of spoken about this, but they may not meet the definition of casual employment. So really linking back to what we've already discussed in relation to that. And potentially accepting the notification would accept compliance or affect compliance with a recruitment process or some sort of grounds of Commonwealth or state legislation. So that there are obviously fair and reasonable grounds for declining this. And with that assessment, again, you really need to sort of take your brain into that third-party reasonable perspective, look at whether they meet that definition of the casual standard, and whether there's maybe significant impacts on the operation of the business if you change them to a permanent employee, whatever that may be. So really looking at that reasonable and fair aspect in looking at that, and also making sure that you've got evidence behind the fact that you've made that choice. If a dispute does arise and it can't be resolved at the workplace level, that may be escalated to the Commission, much like the case that was the reason this came into play. And the Commission will obviously generally first try to resolve the dispute in an informal way, potentially through a mediation or conciliation, but it can obviously escalate like the previous case that we discussed as well. So obviously the better option is to make sure that we're deliberating and going through these disputes for employee choice within the workplace. Okay. This was just a really quick one in regards to the employee choice framework and the process. I'm not going to go too much into this because we've kind of touched base on it, but I did just want to put it into a little bit more of a flow chart for everyone. Again, this will be sent through to everyone, of course, as well. But yeah, just kind of wanted to succinctly put it through with a bit of a checklist for people. Just with casual employees, this isn't something that is quite new to casual employees definitions, but I did just want to touch on it because it's something that we see a lot of businesses forgetting. Essentially, when you've got any new employee, there is also the Fair Work information statement that's required to be sent to all employees as soon as you start. As well as that, if you've got any casual employees that start, you will be required to send this casual employment information statement. If you have not been sending either of those to any of your staff to date, that's perfectly fine. Just start sending it out, maybe just a blanket email to all of your staff noting that they need to look and review at this document is more than enough to comply with those arrangements. So a quick little summary here. What does this mean for your business? Obviously, just put in steps at this stage to really manage and look at the administrative burden that comes with casual employees and making sure that you're looking at, record keeping, looking at that potential for a casual to come forward, reviewing your casual employment contracts to make sure that the terms indicate no firm advancement or commitment of continuation of work. And with that onboarding process, making sure that in casual employees are aware that they're engaged as casuals. But the main thing I would say is that casual employment audit. So look at all your casuals, look at your roster system, look at whether there's permanent employees in the same role. And that'll be a really good indicator of any potential upcoming claims from employees that may come forward. And obviously just really noting the casual change process. So just ensuring your business is aware of everything we've kind of discussed today. So it's a bit slow, but now looking at the right to disconnect. Again, this is one that employees are very aware of, and one I really want to touch on because there is that 2025 date for your small business employers. It has come into play already for non-small business employers, and even for your small business employers, I would suggest just redefining your work hours and you're looking at your right to disconnect now, because it's going to be something that's going to come in place soon. Might as well, begin the process now. Basically, with this right to disconnect, I will say practically, it can be something that's difficult to monitor and take into consideration, but basically means when we're looking at employees who potentially work outside their working hours, the employees can refuse to monitor, read, respond, contact, whatever it may be, their employer outside of that period. As you can imagine, the intention behind this right to disconnect is just making sure that employers aren't forcing employees to be, really constantly on their phone or constantly on their emails, even when not in working period. And it's really focused on work health and safety aspect of that burnout, essentially. So I think if we always just make sure when we're thinking about right to disconnect, we're thinking about that intention of why they've created this. And that can really help with that assessment of whether something is reasonable or unreasonable to request of an employer or an employee, sorry. We'll go through a few reasonable or unreasonable ones, but just making sure that when we're looking at that, we kind of have something in our head of, is this outside of working hours? Firstly, is this something where, it could take a substantial amount of time, could reflect in potential burnout? Those are sort of questions that we should be asking ourselves quite consistently when looking at work outside of work hours. So basically, again, looking at that disconnection if it's unreasonable. Unreasonable if the contact or attempted contact is required by law. Again, it's a tough one. We always talk about that reasonable word when it comes to law. So, difficult to see what comes under that banner, but, factors may be the reason for the contact, how the contact is made, and how much disruption it causes the employee, and any compensation that the employee receives. So that compensation is what I want to focus on really quickly. If the employee is paid an allowance or paid a salary that is set off to include an allowance to be available for work outside of their work hours, obviously, it would be unreasonable for the employee to request that they don't action that, especially if it's a part of their position description and their level of responsibility. So that can obviously be taken into consideration with this. I will say an example that has come up quite often is potentially for your casual staff. If there's a change to their roster or if there is a request for additional work as to whether they're available, this may fall under that reasonable factor in the fact that, seeing a small text message, not being required to maybe respond to that text message doesn't quite cause much disruption. You're not requiring them to be sitting on your phone or be on standby. That's where that may sit in that reasonable aspect for them to be, aware of that message essentially. So, contacts can be obviously in accordance with those usual arrangements. So that may be urgent work or emergency roster changes, especially if that's happening quite infrequently as well. That can be a consideration in addition to this also. You will see that last dot point, the employee's personal circumstances, including family or caring responsibilities. Obviously, that can be really tailored to the employee specifically, so can be difficult, but they will most likely come forward and discuss that with you as the employee as well. General protections. So I'm going to really briefly touch on general protections, but basically it's a concern when there's a termination or an adverse action where basically an employee has been adversely taken action against or terminated or, in some form disrupted due to something that is a workplace right. So this right to disconnect is now included in this workplace right of general protections under the Fair Work Act. So basically, if an employee has argued that they're refusing to respond to an out of hours message or email, again, whatever it may be, and there's an argument that they've been disciplined, performance managed, potentially terminated due to the fact that they've refused to work outside of their working hours, this is where that workplace right element can come in and potential claims to the business may become a concern. So really keeping that in mind that we aren't taking disciplinary action, or at least giving one of us a call prior to taking any kind of disciplinary action on that. I will say there's obviously circumstances where that changes. So if it's there within their job description or within their salary to make those calls or emails, again, that's where it may be reasonable to discipline or performance manage an employee, but just being quite careful of the fact that it is that addition now to general protections. With dispute resolution, much like casual conversion, we would suggest to, as much as possible, work within the company with any of those disputes. So really pushing that employees communicate with their managers or their senior management with any concerns of that right to disconnect, and making sure that we can try as much as possible to resolve it at that workplace level. Otherwise, much like previously, the employees or the employers can go to the Fair Work Commission to deal with this dispute and potentially take orders for that process. But we are obviously trying to avoid that as much as possible. Psychosocial hazards is something I really want to touch on. The next few pieces, we're looking really at the legal framework for work health and safety. With the 2024 and 2025 changes, there is a really high push for work health and safety care, whether it be psychosocial or sexual harassment. And the Fair Work Commission are taking a really high standard and intention when it comes to mental health over the next few years, which is obviously wonderful for employees, but something to be very aware of as an employer as well. And it may be that as employers, you're seeing a higher push or requirement when it comes to mental health from your employees too. So really good to keep on top of these frameworks. I guess the difficult part for the legal frameworks is each state is governed by their own act and development. With the psychosocial, most states have adopted the same act except for Victoria. And Victoria maintains its same process of the Occupational Health and Safety Act in regards to psychosocial. And we'll go through a little bit more information in regards to psychosocial as well. Just to really touch on it, these are the regulators and the regulations for each state. So as you can see, Safe Work or WorkSafe are your prominent regulators or the people who are creating these changes within each state. But just wanted to pop this on a bit of a slide for everyone quickly. So the key factors for psychosocial and that, again, intention behind the process or the changes is really looking at the overload, burnout, exposure to traumatic events, potentially low job control, continuation of conflict, poor support. So these are things that obviously have a really big factor more on your mental health or mental load, obviously in comparison to something such as more of a physical concern like a broken bone or a cut. These are just a few examples. So poor procedural process, bullying or harassment, inadequate reward and recognition. These are all sort of, again, key factors or examples of what can affect a person's psychosocial process within a business. It's difficult to obviously manage all of these, especially in your more smaller businesses, but really just trying to look at the opposite of all of these is something that we can try and focus on. So having it really in place, really stringent policies in regards to bullying and harassment, making sure if you do have more remote or isolated work that you're having someone check in really consistently with your employees. And we'll go through a few kind of key controls and practical tips in the next slide. But, again, just focusing, I suppose, on these factors and how we can try and resolve them. I will say it's difficult to manage psychosocial. Obviously, everyone is different and everyone has their own mental health concerns or requirements that may need to be managed individually with each employee, but just trying as best as we can and having that, understanding that we're trying to mitigate the psychosocial concerns as much as possible as a business is really that threshold. And that mitigate word is really important, that we're trying to, again, mitigate as much as possible, some of these factors that can contribute. So as promised, just a few practical tips. EAP is a wonderful one if you've got access or you can give access to your employees to an EAP program. One of those examples being Connect Psych Services, a perfect way to make sure that you're having professionals in the psychological space, can be a really good factor for that. A few other parts that are quite easy is providing really clear job descriptions and involving your employees in the decision making of that job description. Policies and procedures, perfect. Having your employee handbook and code of conduct as a bit of a standard of requirement for each business is a really good basis to start with when it comes to these practical tips. A really easy one, again, support for remote or isolated workers. Having a weekly check-in, making sure your manager is sort of maybe on Teams checking in with your employees every now and then. You don't know how much that can mean to an employee who is, maybe not having constant discussions and communication with staff. Regular debriefing sessions, again, you don't know how much that can mean to an employee at the time, and making sure that you're having that open communication forum, building that communication of a safe community, wonderful ways to make sure that you're showing as a business that you're trying to avoid any risk of psychosocial. Formal recognition programs, not something that's always, I guess, applicable or able to be managed with every employer or business, but even without a monetary value for that, a recognition program can be something where each month there's a shout out or a blurb from each manager or internal team, where we're really acknowledging and showing staff who are doing a wonderful job and going above and beyond for clients maybe. So it doesn't always have to be costly or a monetary thing. It really is just making sure that people feel as though there's that recognition for a job well done, and that they're getting that support from an employer as well. So another work health and safety that we've touched on, and I'm going to discuss a little bit more, is obviously sexual harassment, and that positive duty under the Sexual Harassment, Sex Discrimination Act, apologies. So I will say this kind of came in within the December 2023, but the reason I wanted to push on it more is 2024 was sort of a year where they were providing resources and setting up that structure. And 2025 is going to be, likely, as you can imagine, a real high focus on the enforcement side of things for this. So, as a business, really making sure that we're compliant and understanding of this concern is something I wanted to focus on within this conversation. So under the Sex Discrimination Act, as well as the Fair Work Act, I will say, sexual discrimination or harassment is defined as a few different things, and some of those examples can be unwelcome sexual advances, unwelcome or unwanted sexual comments or jokes, requests for sexual favors, sexually explicit texts, emails, images, any physical touching, which can be considered inappropriate behavior, or basically any conduct of a sexual nature that makes someone feel humiliated, intimidated, or offended. Obviously, that threshold is quite high, and it's quite broad as well. And I'd say the reason or intention behind that is to allow for a multitude of different situations and examples, with those definitions. And the requirement or that legal threshold is that a reasonable person must consider the behavior, again, those words again, offensive, intimidating, or inappropriate within the workplace context. And intent doesn't matter with that. So what matters is how the behavior could have been perceived. So someone may, inappropriately take action of an unwelcome sexual advance, and whether there's that intent to create harm or an offensive behavior is almost irrelevant. It's realistically how that behavior is going to be received. We'll go through a few practical tips as well. Obviously, when it comes to sexual harassment, it's something that, as a business, can we exactly remove it completely? Always a difficult one. But much like the previous concerns for health, for psychosocial, it's really just making sure that as a business we're trying to mitigate it and action a plan to make sure that we're trying as actively as possible to avoid any sexual harassment. That I will say the Fair Work Commission and other regulatory boards will take into consideration whether there's that element or whether there's that aspect that the employer has tried to mitigate it, and it's just something that's happened outside of their control. So there is that understanding. Apologies. So implementing a sexual harassment policy, I've touched on this before, code of conduct, employee handbook, but making sure that those have a really clear understanding and policy of sexual harassment, and that notes a real zero tolerance as a company for harassment. Making sure the policy is really easily accessible, regularly reviewed, and employees either sign or acknowledge that they understand confidently how to report issues. Training is another big one. So whether that be to your managers and your senior managers on how to undergo any kind of reporting or understanding, and including, real world examples of inappropriate conduct in that definition. So it may even be that you talk through with your managers what we've discussed today, and that definition here. And that should obviously continue and have refreshers every now and then, whether it be annually or hopefully annually, but whenever possible. With that policy, I think just making sure as well that you've got strong reporting and investigation processes. So having multiple channels for reporting, whether it be potentially an anonymous reporting line, HR, their manager, an employee may not feel comfortable going to their manager, whether it's that person who is the reason that they're putting through a claim. So having those multiple reporting channels can be really important. And making sure that investigations are done in a really prompt and fair and confidential manner. Again, obviously suggest you give us a call if something has come forward and you are looking to go through an investigation process, as there are requirements when it comes to a formal process. Taking immediate action on complaints, already sort of touched on that, but making sure that there's no delay in that process, that can really expose the business to liability if there is delay. If it's found that a complaint has come forward and it's taken 3 weeks for the business to look at that, that can be where the commission or some of our regulatory boards can note that we aren't taking that action or trying to mitigate sexual harassment. I've mentioned this a few times, but records are something I harp on with, I think, in every webinar, but really making sure that you've got detailed records of complaints and responses, even if it's something quite small or something that wasn't quite even managed in a formal process because it was managed and concluded in an informal way. Making sure that that's still kept as a record is really important, so that if we can see maybe with the next time when it does need to be managed more formally or it is more of a serious process, we've got that continuation or that process where we've seen it previously, and we can have a stronger hold or understanding between two employees or whatever it may be. Obviously, investigations can lead to disciplinary action, termination if necessary. Again, give us a call to mitigate or go through any risks when looking at termination or disciplinary action. Good idea to sort of, much like our previous discussions, but look at sort of audits of your areas. And another reason why reporting is so important is that you can look potentially at different teams or events or whatever it may be to identify those high risk areas. You can see I've put as an example those after hours events. Most of our calls in regards to this are in those after hours events where maybe alcohol or text messages occur. So making sure that if you are having after hours events, you're noting that there is still that line of professionalism that is required as an employee, and maybe having that extra understanding and communication and training to your staff prior to any of those events. With July not too far away, I suppose, people may be having end of financial year parties. And as you can imagine, just a remember or reminder to look at this prior to any kind of end of year parties as well. And that's really focusing on taking that preventative action. As you can imagine, an after hours event, we can't control everything. We may have an event that runs until 9 o'clock and then everyone goes for a continuation after that. Again, we can't control everything, but having those elements where we have had staff available, access to a way to get home, training and policies for this, and that reminder and identification of that high risk area is going to be somewhere where basically you're protecting your business as much as possible. And obviously just demonstration of that leadership commitment. So, senior management need to actively support anti-harassment initiatives, and just, it's not always easy, but implementing a culture of respect and accountability, that really focusing back on that zero tolerance. So, leaders should be trying to recognize and address inappropriate behavior, and taking action immediately on that will show that there's that culture of accountability as a business and that zero tolerance reinforcement aspect. So wage underpayments are a big one this year. We'll go straight into it. 1 January 2025. But basically the changes have been that it's created that criminal offence option should an employer commit an offence of underpayment or wages. And when we're looking quite heavily on intent. And essentially the employer has been required to make a payment to an employee or on behalf of the employee and have intentionally engaged in conduct which results in their failure to pay that amount. You can see here the fines are quite large, and for individuals can actually be imprisonment as well, so a max of 10 years. Obviously that's a maximum, and I will say obviously that may not be the case for every wage element, but it's just allowing for that increased enforcement on businesses. And it really just focuses on the fact that businesses cannot afford to be complacent with this, and making sure that you're looking at this quite urgently, as one of your major closing loophole changes, I will say. So intentional wage theft, it can be quite obvious in nature, I will say, but basically you would need to prove in a system where you have been noted of wage theft, that you need to prove beyond a reasonable doubt that you did not intentionally choose to fail to pay your employees your minimum statutory entitlements. Underpayments I've noted here that are accidental would not be caught by those provisions, but that would obviously need to be undertaken and an assessment and audit of the understanding. So a couple pieces to our aspect there is that intentional wage occurs if there's been an unlawful offset imposed by the employer. So the employer has noted that there's a larger salary than award basis, and that requirement for employees to spend wages on a non-benefit as well. So those are sort of your two ones that tend to happen quite often, within that process. A few parts that basically won't be considered as wage theft, maybe genuine mistakes, errors in payroll just due to a few incorrect calculations potentially, complex award misinterpretation. Some awards, as people will know, can be extremely complex. So, if a business makes a reasonable effort to try and comply, but then later realize that there's maybe a miscalculation, they may be able to avoid penalties. So again, just a few tips and tricks to finish off. As soon as possible, I would suggest conducting a payroll audit. Give us a call, utilize the line. A few aspects to obviously look at, of course, are looking to make sure that you're up to date with the super contributions. Look at any kind of trend following the 1st July last year wage increases for awards. And keeping a breadth with your award for elements such as overtime, penalty rates, and allowances that are correctly applied. As mentioned, some awards are extremely complex. So, getting ahead of that and having that audit of your business in terms of which award you're under, which award each roles are under, and then the applicable rates for that are extremely important in this process. Ensuring obviously your HR and your payroll software is considered or configured to reflect those award changes and understandings. and regularly looking at any kind of Fair Work Act changes or being aware of those changes is crucial. Maintaining detailed timesheets and pay slips, very crucial. Making sure your pay slips have everything that's required within them. So a breakdown of maybe overtime, leave loading, annual leave, if those are applicable. And that can really help with the parameters of employees to be aware of what's actually in the breakdown of their hourly or salary rate. Just noting here as well that payroll records need to be kept for at least 7 years. That's just a blanket. So making sure that you're sort of keeping those records somewhere, whether it be in your HR or your payroll software. And implementing a clear reporting process for employees who do flag payroll discrepancies. So again, records. If there is someone who flags a complaint, it ends up being that they are paid, well within the award or well within the compliance. Still keeping a record of that to show that that matter was closed off, discussed with the employee and communicated. Address complaints promptly. That one's a fairly easy one, but any kind of response or consideration or complaint of a wage dispute that has a delay or can be seen that you're ignoring the complaint really increases that legal risk. So having immediate turnaround and discussion with that is really crucial. And of course, as I've said, awards can be very complex. You can have multiple pay structures, all those sort of elements. So, feel free to give us a call or even, have a more in-depth audit discussion with our team as well. And just sort of noting that there are some businesses in high-risk industries with that. So hospitality, retail, construction, really looking at those sort of high-risk roles to catch issues early. So I've spoken at all of you for a very long time now, but as mentioned, just to flag, we are more than happy to take any of your questions over the phone line as well. So please feel free to do so, and you'll speak to either myself or one of our consultants.
All right, thank you very much, Olivia. There's just a couple of questions that have come in, so we'll just ask those. If you do have any questions for Olivia about this or any other aspect of HR issues, please just do use your Q&A function there. But I guess, one of the key differences between casual and permanent employees, Olivia, is the ability to turn down work. But conversely, if you fall into a standard shift pattern, you perhaps are no longer a casual. But is it still a key differentiator that even if you are still working a regular shift pattern, but you can practically say no to your boss around shift, are you still a casual?
Yeah, it could still be definitely a consideration of that, of course. But I think when you're looking at the definition, I always really highly look at, that indefinite continuation of work rather than potentially the roster. So, that's sort of your main factor that you want to look at rather than potentially the fact that the employee can say no to work, because as a part-timer, you can obviously do that as well. So I wouldn't use it as a high factor in that consideration, but it certainly can be a consideration in that as well.
All right, thank you. And what are the legal implications if you misclassify workers as casual or permanent?
Yeah, so similarly to the wage elements, they can have that wage theft process option as well. So, that criminalization option and high fines and monetary values also. But most of the time they will try to push that they are fixed internally or discussed internally. And most of the time, again, they will have a mediation process, which is more likely that will be the consideration of concern.
Okay, all right, thank you. The last question we had was just around auditing, and you've you've talked about the need to audit your contractor requirements. What specifically should HR experts in businesses be doing to make sure that they're currently meeting the law around contractor arrangements?
Yeah, so contractor arrangements is something we obviously didn't touch on completely within this conversation, but is something really important in regards to that sham contracting element. So looking at basically, and I would suggest even looking at the ATO website as a really good starting point, because they have a multi-factor test within there. Again, we can obviously discuss that multi-factor test with you as well, where essentially you will be looking at a number of different options or a number of different elements in their role, which can affect whether they're casual or an employee. I guess as an example, some of those might be whether they're required to have their own tools, whether they're required to have their own insurance or understanding of insurance. And a big factor of that may be the way or the manner in which they are paid as well, or the requirement of their roster. Much like casuals, I always kind of take the reasonable factor of, do you have other employees in this role, and then one that's a contractor. And, again, if that contractor is really looking like an employee in terms of, their roster, the way they're paid, the way that they're required to have tools or that management, again, more likely that they're an employee than a contractor.
Okay. Well, thank you very much, Olivia. Those were the questions that we had coming in. So thank you very much for your time. To our audience, I hope you found that really useful. We will make this recording available to you, and we'll post it up on our internet site. If you do have any questions about specific issues or the application of these rules, do feel free to reach out to our WR line. You can reach us on 1300 277 881 or email us at wradvice@canberrabusiness.com. Olivia, thanks very much for your time.
Thank you.